Mr. Boyd, you're charged with possession of not more than 20 grams of marijuana and altering or destroying evidence. Is there an offer for him?
Yes, Judge. It'd be a 2-year probation offer with an adjudication of guilt, standard court cost for possession, which is $615, and substance abuse classes, and any treatment if recommended.
You want to do that, or you want an attorney?
Can I talk to my mom real quick?
Yeah, go ahead.
I guess I need to get a lawyer.
All right, appoint public defender.
I can get a lawyer. You gonna hire one?
Are you going to
Yes,
hire a
sir.
lawyer? Okay. Well, your court date is December 30th, okay?
Okay.
Just tell your lawyer that, they'll know what to do. Thank you.
Do I need this or? That's
Yeah, go ahead, take it. Calvin Dawes. Mr. Dawes, you're charged with synthetic narcotic distribution. Would you like to have an attorney to represent you?
Yeah.
I'll appoint public defender.
Your Honor, will enter a not guilty plea, request 15 days for pre-arraignment motions, demand trial by jury, and leave this set for pretrial.
December 30th, thank you.
December 30th?
Yeah.
Give me a call.
Get with your attorney before then, okay?
All right, thank you.
Bobby Lee Duval. Charged with felony battery. You want an attorney?
Yes, please.
I'll appoint public defender.
Your Honor, we enter a not guilty plea, request 15 days for pre-arraignment motions, demand trial by jury, and leave this set for pretrial.
Thank you. December 30th. Devin Nathaniel Jones. Is Devin Nathaniel Jones here? No bond, Capias. Jeff Allen Ledoux. Charged with criminal mischief, over $1,000. You want an attorney?
Yes, sir.
Judge, I already have one.
You do? Okay, appoint public defender.
Get your case number here. All right, Judge, I'm just going to enter a plea of not guilty on his behalf unless the state's got an offer they want to announce.
December 30th, thank you.
Thank you, Judge. All right, make another appointment, come in and see me, so I need to take you on that.
Cody Allen Lavin. Charged with criminal mischief, over $1,000. You want an attorney?
Yes, sir.
Public defender's appointed.
Or a not guilty plea, request trial by jury.
December 30th, okay? Devin Walter Little. Charged with possession of drugs without a prescription and 2 counts of narcotics possession. or narcotic equipment possession, 2 counts. You want an attorney?
Yes, sir.
I'll appoint the public defender. This is Mr. Little. Devin Little.
Yes, sir. Judge, I'm going to enter a plea of not guilty on his behalf. Let me see that for just a second. And 15 days pre-arraignment motions.
All right, December 30th.
Thank you, Judge.
Thank you, Your Honor.
Victoria McLeod.
Give me a card, just make it. Don't see me. All right, you keep that.
Yeah, it's, Charlie won't let us get off of them until we do the paperwork, even though we know it.
Charged with possession of controlled substance without a prescription and in possession of narcotic equipment. You want an attorney?
Yes, sir.
Appoint the public defender.
All right, Ms. McLeod, that's yours. You hang on to it. Give me just 1 second. Judge, I'll enter a plea of not guilty on her behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right, December 30th.
Thank you. Make a appointment.
Justin Peacock. What is his charge? I can't seem to make it out on my docket.
Possession of a firearm or weapon by a convicted felon?
Okay. You want an attorney?
No, sir.
State got an offer for him? Are you
Yeah.
gonna, go ahead.
Yes, Your Honor. It would be for pleading as charged, adjudication, standard probation 12 months, community service 50 hours, no alcohol, controlled substance, forfeit the firearm, no possession of weapons, cost of prosecution, and court costs.
No, sir.
Appoint the public defender. Are you gonna get an attorney?
Yeah, I'm gonna get an attorney.
Okay. December 12th, excuse me, December 30th. December 30th, okay? Thank you. Jeremy Altman.
Your Honor, Tim Gibbs on behalf of Mr. Jeremy Ottman, 24 CF 1777.
Mr. Altman, you charged with battery on a person 65 years or older and felony battery. Court's appointed public defender.
Judge will enter plea not guilty and leave the set for pretrial, request 15 days
All
for
right,
pre-arraignment
December
motions.
30th, thank you.
See and try to get it.
What about the FDA?
The FTA, we'll take a look at that too. Yeah, we'll take a look at that.
Lori Lee Beckman.
Oh, she's in.
All right, it's Beckham, I guess, Beckham.
Ms. Beckham?
Ms. Beckham, this is arraignment. You're charged with vehicle theft and resisting an officer without violence.
Right. Judge will enter a not guilty plea, leave this set for pretrial, and request 15 days for pre-arraignment motions, demand trial by jury.
December 30th, excuse
Judge.
me, yeah, December 30th.
Thank you. I'll come
Lindsay Billingsley.
Right here, sir? Okay.
Billingsley, you're charged with fleeing a police officer, operating motor vehicle without a valid license, DUI, with alcohol or drugs, and resisting an officer without violence.
Judge, we're seeing if the state had made an offer since Ms. Billingsley had previously gotten an FTA due to the arraignments being rescheduled due to the storm, we're seeing if there's an offer that she is interested in taking that might get her out.
Yes, the offer would be to plea as charged, withhold adjudication in the driving on a suspended license, and in the DUI. Adjudicate on the DUI and the fleeing and eluding. The state would dismiss the resisting without violence. It'd be a 12-month probation offer with the DUI terms, which I can announce if necessary.
Y'all gonna have to write it up.
Over 0.15,
No, it would be it'd be
$1,000 fine.
$1,000 fine, $551.73 in court costs.
Y'all write it up for me.
I can write that up and we'll bring her back. Thank you, Judge. You don't have to if you don't want to. That's the offer.
I want the probation.
Let me write it up and we'll come back and do it later.
I've never done this before.
You're okay, yeah. We'll write it up and we'll take care of it this afternoon. I'll go over with you. I just got to type it out for you.
Does that mean?
You should be able to go home today. Yeah, there shouldn't be anything else. Yeah, so I'll get that written up, okay? We'll see you in a little bit.
Thank you.
Terry Campbell.
Your Honor, Tim Gibbs on behalf of Ms. Terry Campbell. Judge, we're here on arraignment for 24 CF 2096.
Charged, Ms. Campbell charged with 6 counts of burglary of an unoccupied conveyance and possession of a controlled substance without a prescription.
Judge will enter a not guilty plea, demand 15 days for demand trial by jury, request 15 days for pre-arraignment motions. We had originally, I believe, also set for a bond hearing today, but if the court recalls on Monday, the court went ahead and denied that.
December 30th, thank you.
Thank you, Judge. We'll have to come back December 30th, okay? No, he said that Monday that he wasn't willing to do a bond at this time.
Winona Carpenter.
Your Honor, Tim Gibbs on behalf of Ms. Winona Carpenter, Judge, 24 CF 2045.
You're charged with possession of a weapon by convicted felon, possession of narcotics equipment.
Judge will enter a plea of not guilty, request 15 days. We can't do that today, but we'll do that later. Because today is just arraignment.
December 30th, thank you.
Judge.
Terry Lee Chesser.
What's 1129? How much I got until the 1129?
I'll come see you. I'll come see you. And if I can get you in next week, I will. Okay. Your Honor, Tim Gibbs on behalf of Mr. Terry Cheshire, Judge, this is 24 CF 2084. Will enter a not guilty plea, request 15 days for pre-arraignment motions, demand trial by jury.
Right, you're charged with 2 counts of possession of a controlled substance without a prescription and driving license suspended habitual second or subsequent conviction.
Thank you, Judge.
December 30th.
You need a card?
Mark Danridge.
Your Honor, Tim Gibbs on behalf of Mr. Mark Dandridge, 24 CF 1905. Judge will enter a not guilty plea today. I intended to ask Mr. Parker, who we had this morning, the alleged victim in the case, what his position was, if we could potentially get that on the record, but I had forgotten to do that. But we'll enter a not guilty plea on this case, and I'd like to go ahead and leave it reset for next Thursday for a bond hearing, so I can get that motion filed as well.
No objection.
All right, November 7th.
Yeah, we'll cover it.
You're charged with aggravated assault with deadly weapon and criminal mischief.
And I'd like to leave him on next Thursday's morning docket for that.
All right.
Thank you, Judge. That way I can get you in for a bond hearing, too. So try to get you a bond next week, too.
Zev Graham Elderman.
Your Honor, Tim Gibbs on behalf of Mr. Zev Edelman, 24 CF 2205.
You're charged with fleeing, attempting to elude at high speed, failure to have required endorsement on driver's license, reckless driving, driving license suspended, first offense.
Judge will enter a not guilty plea and leave this set for pretrial so we can review discovery.
December 30th.
Thank you, Judge. Give me a call.
Teresa Edwards.
Edwards. Your Honor, Tim Gibbs on behalf of Ms. Teresa Edwards, Judge 24 CF 2166.
Charged with felony battery, Miss Edwards.
Judge, I believe she does want to accept the state's offer in this case. I'm going to write that up and have her back this afternoon.
All right, thank you.
Back this afternoon.
All right, thank you.
Thank you. I'll write that up and go over it with you. We're going to bring you right back out here if you still want to take that offer, okay?
Elijah Falls. Nobon Capius. Anthony Firestone.
Your Honor, Tim Gibbs on behalf of Mr. Anthony Firestone, 24 CF 2063. Judge will enter a not guilty plea, request 15 days for pre-arraignment motions, demand trial by jury.
All right, you're charged with possession of controlled substance without a prescription and DUI, third offense, within 10 years.
Thank you, Judge.
December 30th. Michael Gomillion.
Your Honor, Tim Gibbs on behalf of Mr. Michael Gomillion, 24 CF 2215. Judge will enter a plea of not guilty, request 15 days for pre-arraignment motions, demand trial by jury.
All right, you're charged with possession of a controlled substance, December 30th.
Thank you, Judge.
Sir, we need DNA on Mr. Gomillion.
They have to collect your DNA under statute.
Have a seat on the front row right there. To the left.
Gerald Green.
He's an inmate, Your Honor. We recognized a conflict of interest in representing Mr. Green, so I will be having to move to withdraw, but we certainly can inform him. Come on, Mr. Green. Your Honor, Tim Gibbs on behalf of Gerald Green, 24 CF 2150. As I just stated, we did recognize a conflict of interest. We would have to move to withdraw. I don't know if the state has an offer for Mr. Green, in case he's interested in hearing it at least.
He's charged with battery on a detained person.
It's true. We had a note out, we have a request out to the victim in the case who is incarcerated and I believe represented by the South End Public Defender's Office. So at this time, there's no offer.
All right, I'm going to file your motion to withdraw and appoint Regional Conflict Counsel. I'm going to appoint you another attorney, okay? The public defender's got a conflict.
Represents the alleged victim in this case. We can't represent both of you. So
They couldn't offer me anything right now.
they don't have anything right now. Whenever they're going to try to talk to the alleged victim. They're going to try to talk to the alleged victim to see if there's anything they can do to resolve it.
Judge, we could put them on for 11/7 and I might have an offer.
All right, well, Miss Flowers is.
I can inform her. I've already reached out to her.
All right, November 7th.
Yeah. She'll come see if she can get it resolved for you.
Jonathan Hawes. Charged with accessory after the fact of a third-degree felony.
Here's your copy, Mr. Hollis. Yes, sir, Judge. I'm going to enter a plea of not guilty on his behalf, 15 days pre-arraignment motions and trial by jury.
All right, December 30th.
Need to make an appointment, come see me.
Becky Marie Hicks.
Yeah.
Becky Marie Hicks. Charged with petty theft with 2 priors and trespassing to structure.
All right. Judge, I'll enter a plea of not guilty on her behalf, request 15 days pre-arraignment motions and trial by jury.
I want to come back. I want to do it today, though. I want to go to the judge.
All right, sorry, Judge,
I want to take care of it today if possible.
she wants to enter a straight-up plea today, Judge. I've previously met with her and done up an agreement to that effect. All right, this is the one for the straight-up plea, if that's what you want to do.
Yes, sir.
Need to get your signature on the next to the last page.
Yes, sir.
Okay. I'll date it for you.
Ms. Hicks, will you please raise your right hand and be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
All right.
Judge, for the court's information, what I'm showing as her guideline score is 8.4 total sentence points, so she's less than 22.
You want to enter a plea in 24 CF 2167 to a felony third-degree petty theft and a second-degree misdemeanor trespass. And in 24 CF 2286, a third-degree battery, third-degree felony battery. So you want to enter a no contest plea to those charges?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you happy with the work Mr. Williams did for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Is there any recommendation on a sentence?
You wanted probation, is that it?
I'm asking for that. If not, it was a lower sentence.
Judge, we're requesting probation. If the court's not inclined to give her probation, then a lower sentence and essentially a time-served sentence.
How much time has she served?
Just 34 days, Judge.
Today.
She got a prior record?
She does judge their misdemeanors.
I mean, how many?
Oh. About 21.
21 what? 21,
Misdemeanors, Judge.
21 misdemeanors?
Yes, sir.
Trespassing.
What kind of misdemeanors are they?
4 driving on a suspended license, 4 resisting without violence, 9 trespass, 1 retail theft, 1 violation of an injunction for protection, 1 petty theft, and 1 disorderly intox.
And 24 CF 2167 on the felony petty theft, court sends you 11 months, 29 days with credit for time served. On count 2, 60 days, Okaloosa County Jail concurrent. And 24 CF 2286, the battery, 11 month, 29 days, county jail concurrent.
And those are running concurrent, Judge?
Yeah, all of them concurrent.
11/29?
Yes, ma'am.
Oh, my gosh. Thank you.
All right, Ms. Hicks, if you want that, you can take that and
So I
keep
should
it.
have took the state off. Sorry, go back on number again.
No, ma'am, you really can't.
Okay, thank you.
What you, since it, okay.
Marcia Henson, or ISIS Marcia Henson. Twenty-four CF 2042.
Since this is your copy, okay? Judge, I'm going to enter a plea of not guilty on Ms. Henson's behalf. Request 15 days for any pre-arraignment motions.
All right, Ms. Henson charged with aggravated assault with deadly weapon and battery causing bodily harm. So we'll see you December 30th. Okay?
All righty, ma'am. You need to make an appointment, come by and see me.
Gary Lee Hudson.
Hudson.
Gary, come on out. Judge, I'm going to enter a plea of not guilty on Mr. Hudson's behalf.
This is 24 CF 2235. Mr. Hudson charged with public order crime, unauthorized use of 911 number. See you December 30th.
Thank you, Judge. And just for the record, it'll be trial by jury. All right, Gary.
When's the next court date?
12/30, December 30th.
Okay.
Harvey Lee Jackson.
Mr. Jackson, this is your copy, sir.
Yes, sir.
Judge, this is Harvey Lee Jackson. I'll be entering a plea of not guilty on his behalf. Request 15 days for any pre-arraignment motions and demand trial by jury.
All right, you're charged with possession of controlled substance without a prescription and possession of narcotics equipment. December 30th.
All right, you need to make an appointment. Come by and see me, okay? Go ahead.
Derek Jemison.
I'm sorry, Judge, what was that name?
Jemison. You are charged with possession of controlled substance without prescription and possession of narcotics equipment.
Judge, I'll enter a plea of not guilty on his behalf. 15 days pre-arraignment motions and trial by jury.
December 30th.
Thank you. Sir, that's your copy. You can keep that.
Robert Jones, 24 CF 2083. Charged with fleeing a law enforcement officer with lights and siren activated and driving license suspended.
Judge, I'll enter a plea of not guilty on his behalf. Request 15 days for any pre-arraignment motions. Actually, give me just 1 second, Judge. Judge, yeah, I'll plead him not guilty.
December
Trial by jury.
30th.
All right. Call the office, make an appointment to see me, okay?
George Ivan King.
This is yours, buddy. Mr. Jones, this is yours.
George Ivan King. Charged with possession of a controlled substance without a prescription.
Judge, I'll enter a plea of not guilty on his behalf. 15 days pre-arraignment motions, trial by jury.
December 30th, thank you.
Make an appointment, come in and see me.
Okay, thank you.
Sasha Lemon. (24 CF 2165).
All right, Ms. Lemon, this is your copy.
Charged with exploiting of elderly, fraudulent use of credit cards 2 or more times within 6 months, and larceny of a credit card.
Judge, I still need to meet with her. I'm going to enter a plea of not guilty on her behalf, request 15 days for any pre-arraignment motions. And ma'am, you need to call and make an
December
appointment.
30th.
Need Miss Lemon's DNA.
Okay.
Randy Mathias.
Matthias.
This is 24 CF 2010. You're charged with third petty theft and trespassing to structure.
Judge, this is Randy Mathias. I'm going to enter a plea of not guilty on his behalf. 15 days pre-arraignment motions and trial by jury.
December 30th.
Okay, Judge, give me just 1 second. He's asked me to check and see if anything's changed since the 9th. Madam Prosecutor, do you have an offer for him? What's that?
Let me look at the file here.
I'm not going to do that today.
So there is no offer at this time.
All right, Judge, looks like we just need to leave him on the docket.
December 30th.
Okay, thank you very much. Mr.
Jason-
Mathias, this is yours, sir.
Jason McDonald.
McDonald.
This is 24 CF 2206. You're charged with possession of controlled substance without a prescription.
McDonald. That's yours. Judge, I'll enter a plea of not guilty on his behalf, request 15 days for pre-arraignment motions. I've got 2 files on him. Do we just have the one here today? Okay.
Yeah.
Enter a plea of not guilty and request trial by jury.
All right, December 30th.
I'll come out and talk with you about it later.
Trelessie McLaughlin. (24 CF 2122). You're charged with possession of cocaine, possession of narcotics equipment, and a driving license suspended, revoked license.
Here is McLaughlin. Hang on just 1 second. There you go. That's for you. It's a copy of the formal charges against you. Judge, I'm going to enter a plea of not guilty on her behalf, request 15 days for pre-arraignment motions.
All right, December 30th.
Thank you. Ma'am, come by the office, or make a appointment at the office. Come by and talk with me about your case, and I'll go over the police report with you, okay? There's actually a lot more information than just that one report.
Yes,
Okay?
thank you.
Okay, ma'am.
Selvin Melendez Contreras. Selvin Melendez Contreras, 24 CF 2284. Noban Capias. William Cockrell Moore.
Mr. Moore.
And Mr. Moore. Mr. Moore, that's for you, okay?
24 CF 2085. He charged with burglary of a dwelling, burglary of a structure or conveyance armed and possession of a weapon by a convicted felon.
Judge, I've already got him set for depots. I'm going to plead him not guilty and set trial by jury.
December 30th.
Thank you, Judge. Okay,
Zaki Moore.
I'll come out and see you
Moore.
after the depots.
Yes, sir. Yes, sir.
It's 24 CF 2046. You're charged with aggravated stalking.
Mr. Moore, this is your copy of the formal charge. Judge, I'll plead him not guilty, request trial by jury.
All right, December 30th.
Thank you, Judge.
Mohammed Morris.
Mr. Morris.
Twenty-four CF 2088, charged with criminal mischief, 2 counts.
Judge, I'm going to enter a plea of not guilty on his behalf, request trial by jury. I'm probably going to be filing a motion in the next couple of days, or actually later today or tomorrow, for speedy trial, so you might want to leave him on for Monday as the 5-day call date.
All right, we'll leave you on for November 7th.
Thank you, Judge.
Thank you.
The order, transport back to DOC. And that is a speedy trial on demand?
Right.
Okay. Yeah, I'm getting that correct for the record. So it's on the
Yes.
record that I advise you to file a speedy on demand. So if it's not did, then I can proceed further with this. That's the purpose.
November 7th, thank you.
November the 7th, okay. Now, can you tell the judge what I said about putting in the order to give me the DOC?
Well,
Can you
sir,
do
when I
that?
talked with you last night, we talked about, since we were doing a speedy trial on it, and you might be going to trial in 2 weeks, holding off on that until we find out when it's set for.
Okay. good.
So that's
All
what I'm
right,
gonna
All right,
do.
my dude.
Okay.
Jonathan Murphy.
Mr. Murphy. Come on out, please.
Mr. Morris, this is a copy of your
24 CF 2181.
There you go, Mr. Murphy.
In charge of aggravated assault and felony battery.
Judge, the aggravated assault, I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions.
December 30th.
Thank you, sir. Okay. I'll come out of the jail and see you once, well, I've got discovery in, I'll go over discovery with you.
Next court date is December 30th.
Yes, sir.
Kenneth Nelson.
Nelson.
Twenty-four CF 2265.
Okay, Judge, Mr. Nelson was in court this morning, and we passed him for me to go over plea agreement. We were hoping to get a different agreement than what had been tendered before. If the court would give me one moment. offering.
All right, December, what day you want?
Judge, I tell you what, let's just set him for December 5th.
All right,
We'll go out to the jail and see him again, and,
you can move it up to November 7th if you can get it worked out.
yes, sir. All right, so we'll just see you back in court on December 5th, and I'll come out and see you between now and then, and we'll talk some more.
Next case is 24 CF 2166, Tyler James Nichols. 24 CF 2044, Justin Wade Nolan. Did we do Matthew Ray Olson?
He took a plea.
And what's your name, please, sir?
Justin Nolan?
Justin Nolan?
Yes, sir.
Okay. Charged with petty theft, 2 prior convictions. I think your attorney's already pled you not guilty. Set you for December 30th, okay?
Yes, sir.
Thank you.
December 30th?
December 30th. Your attorney is
We have to-
Jennifer Flowers, I think.
Okay, we already have your attorney, you're represented by Jennifer Flowers now?
Jennifer Flowers?
Yes, Regional Conflict Counsel.
December 30th.
Tremaine Parker,
Flowers also put a not guilty.
all right, December 30th. Jason Eugene Peavy, or Peavy. 24 CF 2074, possession of controlled substance without prescription and possession of narcotics equipment.
Your Honor, I just gave him the offer. I'm just gonna give him a couple of minutes to read over it and sign it, and we'll call him back up if we could.
All right, 24 CF 2229, Tyler Peavy. Charged with possession of controlled substance without a prescription,
Your Honor, we're gonna enter a not guilty plea, request trial by jury.
December 30th.
Mm-hmm.
24 CF 2214, Marcus Redding.
Your Honor, Mr. Redding is present. We had made a counteroffer to the state. I don't know if they've had an opportunity to make any decisions yet. So at this point, we're gonna enter a not guilty plea, Your Honor, request trial by jury.
Charged with possession of synthetic drug, December 30th. 24 CF 2212, Colton Riggs.
Your Honor, this is Mr. Riggs. We're going to enter a not guilty plea, request trial by jury.
Charged with smuggling contraband, December 30th.
Be back out once I know more, okay?
Angela Russell, 24 CF 2285.
Your Honor, the state filed a null pros on that case, and I did convey that to her, so she left.
24 CF 2145, Herbert Smith.
Your Honor, we're going to request, we're going to enter a not guilty plea, request trial by jury. I did speak with the state, and this may be something that we can work out. I would ask to just put it on for November 7th.
I think we can get it done by then. And we also have a VOP, Your Honor, with Mr. Schmidt, 22416. We could perhaps address that at the same time as well.
All right, November 7th. Thank you.
Yep.
Robert Jeffrey Schofield, 24 CF 2080. Robert Schofield, no bond, capias. Savannah Michelle Scott,
Your Honor, I've spoken with Ms. Scott. She was going to turn herself in Walton County. Her husband has since called and said she's on a no bond, she can't bond out, so she's over in jail in Walton County. Like to enter a not guilty plea and request trial by jury.
no bond, capias. December 30th. Vanessa Surum.
Your Honor, Ms. Sherm is present and approaching.
This is 24 CF 2152. You're charged with burglary of an unoccupied dwelling, unarmed.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
December 30th.
9 a.m. right there. I put it on there for you.
Jason Staton.
Your Honor,
This
Mr. Stanton is in custody. We're going to enter a not guilty plea at this time, request trial by jury.
Charged in 21 CF 48, grand theft,
Not
or
guilty, Your
vehicle
Honor.
theft.
Not guilty, Your Honor. We're going to request trial by jury.
All right, December 30th.
Been appointed yet, though, but I'm pretty sure.
Thank you. Christian James Stewart. 24 CF 2262.
Your Honor, Mr. Stewart is before the court on 24 CF 2262 on a charge of false imprisonment. We're going to enter a not guilty plea at this time, request trial by jury. I am planning on filing a bond reduction motion.
All right.
I'm going to tentatively set it for the 7th.
You're charged with false imprisonment. 24 CF 2262. We'll see you November 7th. Next week. Thank you.
Thank you.
Next case is 24 CF 2274, Travis Scott Stone. Charged with failure to report and register vehicle and failure to report change in employment.
No, but we probably can bring it in earlier if we just have a chance to talk.
Okay. Here is my card. Information. Your next court date is
Set it for December 30th. If you can get it resolved, we'll move it up. Next case is 24 CF 2249, State versus James Upton. No bond, capias. 24 CF 2170, State versus Vincent Waters.
Your Honor, Mr. Waters is present.
Charged with driving license suspended with prior convictions.
Is the state wanting a continuance?
The state is asking for a continuance, Judge. We have not gotten his Missouri driver's record back yet, even though we have requested it from the state of Missouri.
All right, December 30th, and resolve it, we can move it up.
Yes, sir.
Thank you. 23 CF 1614, Scott White.
Your Honor, Mr. White has an offer from the state that I need to get him to sign.
Mr. White, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, Your Honor.
Okay.
For an adjudication withheld on count 1.
Mr. White, you want to enter this is State of Florida versus Scott Allen White, 23 CF 1614. You want to enter a no contest plea to possession of a controlled substance, a third-degree felony, and possession of drug equipment, a first-degree misdemeanor, correct? Did you read and sign this plea and sentencing agreement form?
Yes, Your Honor.
Are you aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea?
No, Your Honor.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers did for you on your case?
Extremely.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 1, possession of controlled substance, you're withheld adjudication. Is it a time served?
Yes, Your Honor.
You're sentenced to time served in Okaloosa County Jail. And on count 2, possession of drug equipment, you're sentenced to time served, and you're adjudicated on that. So withheld on the felony, adjudicated on the misdemeanor. Sentence to time served, concurrent on both. $515 court costs, $100 cost of prosecution, $150 PD fee. Okay. Mickey Lee Wilkes. Mickey Lee Wilkes here. It's 24 CF 2115.
Your Honor, I'm going to convey this to my client. The offer is a plea to a lesser included paraphernalia, which is a misdemeanor. You'd be adjudicated in court costs.
No jail time, no probation.
No jail time, just credit time served, court cost of $270
All right.
with a $50 cost of prosecution, $50 public defender fee, $50 application fee.
Mr. Wilkes, you please raise your right hand to be sworn. You swear the testimony you give before this court is true, so help you God.
Yes, sir.
Stand on the other side. You want to enter a no contest plea, the charge of possession of paraphernalia, a misdemeanor, a lesser charge.
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
I am.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers did for you on your case?
I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Withholds adjudication of guilt. fined you, was it $270 court cost, $50 PD fee, $50 app fee, and $50 cost of prosecution. No probation and no jail time or time served. I think it's no jail time if it's withheld, isn't it? So, okay. No jail time, no probation. Pay that within, those funds within 90 days or it goes to a judgment. Thank you. Isaac Williams.
Williams.
24 CF 2216, you're charged with robbery by, without a firearm.
Your Honor, we're going to enter a not guilty plea, request trial by jury.
December 30th. Thank you. Next case, 24 CF 2162, Robert Willis.
Your Honor, we handled that one this morning.
Is anyone here for arraignment that came in late? Anyone here for court that came in late? What's your name? Ashley Bush, 24 CF 2142. You're charged with possession of controlled substance without a prescription. Court will recall Capias. Do you want an attorney to represent you? I'll appoint the public defender.
Tim Gibbs, Public Defender's Office, Judge Winter, not guilty plea. Leave this set for pretrial. Request 15 days for pre-arraignment motions and demand trial by jury.
December 30th.
Thank you, Judge. Give me a call. Be back here December 30th. Call me today to set up an appointment.
Thank you. We got a couple others ready now?
I have a couple ready for plea, Judge.
Billingsley, come on out, please.
Your Honor, Tim Gibbs on behalf of Miss Lindsay Billingsley, Judge, we're recalling her 24 CF 2030. We have an agreement.
All right, Ms. Billingsley, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God.
Yes, sir, I do.
Thank you.
Just need her to sign the written plea, Judge.
I'm lucky.
Okay, perfect. Sign. Right there for me, please. And today's date, please.
State of Florida versus Lindsay Billingsley, 24 CF 2030. You want to enter a plea of no contest to fleeing or attempting to elude a third-degree felony, DUI first offense over .15, a first-degree misdemeanor, driving license suspended or revoked, a second-degree misdemeanor, and the state's going to dismiss count 4, resisting without violence. Is that right?
No
Okay.
objection to that score sheet, Judge.
Is that what you want to do, Ms. Billingsley?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir, I did.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir, not at all.
Are you happy with the work Mr. Gibbs did for you on your case?
Yes, sir, very. I appreciate it.
All right. Court finds the plea is freely and voluntarily entered. Court accepts it. On count 1 and fleeing or attempting to elude, and 3 DUI first offense over .15, the court adjudicates you guilty, sentences you to 12 months probation. $1,000 fine, $551.73 court costs, 150 PD fee. DUI school, victim impact panel, 6 months driver's license suspension, 10-day vehicle impound, 50 hours community service, reserve jurisdiction on restitution for 90 days, 6 months interlock device. And that's a concurrent sentence on, I believe, on one.
That's for the fleeing and the DUI, Judge.
Yeah. Well, I don't impose these other things on these. The 12 months probation is concurrent. Then the other fines and all that apply to the DUI, not to the count one, correct?
That is correct, Judge. Thank you.
So, in other words, I don't want you get stuck with doubled up fines and all that. Okay.
Yes, sir, I appreciate that.
So your 12 months probation is on your fleeing and attempting to elude. That's it. Waive costs of supervision. You have standard court costs on that. But then on count three, the DUI is where you pick up the fine, the court costs, the DUI school, all those. Okay, you
Yes,
understand?
sir, I understand.
Okay. On count two, the court's going to withhold adjudication, sentence you to 6 months probation concurrent. And in count four, the state's going to drop those charges.
Thank you.
And let's see, the court on 1 and 3 has to adjudicate you guilty on count. And on count 2, the court withholds adjudication of guilt.
Thank you, Judge.
All right.
So you'll get fingerprinted.
How much?
Supervision fees are waived,
Thank
Judge.
you. Switch it up on me.
Yes.
Thank you, Mr. Barrett.
Teresa Edwards.
Your Honor, Tim Gibbs
24.
on behalf of Ms. Teresa Edwards, Judge 24 CF 2116. I believe we've reached an agreement.
Ms. Edwards, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God? Okay. Ms. Edwards, you want to enter a plea of no contest to felony battery?
Ms. Edwards,
Yes.
just speak.
No contest?
Did you want to enter the no contest plea to sign today?
Yes.
Did you read and sign this plea and sentencing agreement form?
Is that the form you just signed?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Okay, I'm not, I'm kind of confused about that, but
So,
You have certain rights you're waiving by entering this plea. You understand that? The right to go to a trial?
yes,
You understand that?
yes, sir.
No one's trying to trick you here, Miss Edwards. The questions are very straightforward.
Yes,
You have the right to a trial, right to remain silent, right to an attorney, right to cross-examine witnesses, right to all those rights and many others, but But you're waiving that by entering this no contest plea. You understand that?
So in order to enter the plea, you waive your right to go to a trial.
All right, bring her back November 7th. I'm not playing games here. November 7th. You could have got out today, Miss Edwards, but you know, here you go, mister.
Very well, thank you.
Who's, did we miss anyone here for arraignment?
Your Honor,
That-
I'm ready now on mine.
Okay.
Jason Peavy. 24 CF 207. I conveyed the offer to Mr. Peavy. He's read over the plea agreement and if I may approach.
All right. 24 CF 2074, Mr. Peavy, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God. All right, you want to enter a no contest plea to possession of a controlled substance, a third-degree felony, possession of drug equipment, a first-degree misdemeanor, correct?
Just to the paraphernalia. Your Honor.
Paraphernalia? Okay, so just to a misdemeanor, and the state's going to drop the charge of possession of a controlled substance, a felony. So you want to enter a plea to a misdemeanor, correct? Did you read and sign this plea and sentencing agreement form?
Yes, sir, I did.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Yes, sir.
Are you happy with the work Ms. Rivers did for you today?
Absolutely.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 2, your judge guilty, sentenced to time served, pay $270 court costs, $50 cost of prosecution, $50 PD fee, and $50 application fee, payable within 90 days or they go to a judgment. State's going to drop the charge on count 1.
That's correct.
And your judge guilty on count 2, okay? Thank you. Anyone else out there for arraignment that I haven't called their name? What's your name? Come on up here. All right, your court date is, your attorney's already filed a not guilty for you. Your court date is December 30th, okay?
Yes, sir.
Thank you. All right, Chase Glover, Miss Dudley. Motion hearing,
Yeah, it is a motion hearing.
okay.
I also have a plea with the inmate as well.
All right, this is 22 CF 1170, State versus Chase Glover.
Yes, sir, Your Honor, we have filed a motion to dismiss. The state had filed a demurrer in this case.
All right, go ahead.
Your Honor, the facts in this case, which are not disputed, are that the defendant was driving, the report says the defendant was driving a vehicle. The issue in this case is trafficking in cocaine and tampering with evidence. The officer who attempted to stop the defendant stated that he saw a bag halfway down the fence across the street. He stated that
Wait, now, he saw what now?
he saw a bag. He
Yeah.
said there's a bag halfway down the fence across the street, because they were on the
Oh,
other side of the
okay.
street.
All right.
He then stated that it's halfway down the parking lot, there's a bag. He didn't know if it flew from the wind or if it was thrown out the passenger window. He said it was a clear bag, and that's on his body camera. Then,
You talking about a little plastic bag?
that's what he alleges. That's what he says. There's a plastic bag. He didn't know where it came from. Deputy Malonis in his body camera states that while he was looking for the bag, he states the officer told him there was a plastic bag. He couldn't tell if it was thrown out of the car or if it could have been something thrown up when they were driving through the parking lot. He didn't know where the bag came from. Deputy Malonis finds an empty clear bag in the parking lot. The deputies then find a bag with white residue inside on the other side of the fence. FGLE gives away to the bag, of the substance in the bag. There were fingerprints taken. There are no latent prints on the bag at all. During his deposition, the officer said he did remember telling the other deputy that he didn't know if the bag flew up off the road or if it came out of the car. He said, I never said I didn't see the bag come out the window, I just wasn't sure. Deputy Malone said in his deposition, he confirmed that the officer told him he didn't know if the bag was thrown out the window or if it was just blown up by the wind. Deputy Malone also confirmed he found several plastic bags on the ground in that area. Based on that, Your Honor, we believe there's a prima facie case of trafficking in cocaine. And in order to establish a prima facie case, Your Honor knows that you have to have evidence of each element of the crime. And to prove that a defendant possessed the substance, the state must prove beyond a reasonable doubt that the defendant knew of the existence of the substance and intentionally exercised control over that substance. In this case, there is no evidence the defendant intentionally exercised control over the substance they found. You have an officer who states he didn't know if the bag came out of the window or if it was knocked up on the ground. He never at any point says, I saw the defendant throw the bag out the window. He never at any point states, I saw the bag come out the window. And there are no fingerprints on the bag. I did provide a case in here where it talks about, it's a 4th DCA 2018 case, McCrae v. State, 265 Southern 3rd, 878. It talks about the fact that they saw the defendant reaching in his waistband and looking over his shoulder. They didn't see anything fall. The backup officer arrived and was told the defendant may have threw something. They go to the area and they find a clear bag with heroin inside, and they didn't test for any prints. And the court overturned that, saying that no one saw the defendant with the drugs or saw him drop or toss anything. That's no different in this case. No one can say, they've said in depositions, on body cameras, no one can say they saw the defendant throw anything in this case. There's no fingerprints on the bag. There is nothing to tie the defendant to those items. And based on that, since there's no evidence to show that he intentionally exercised control, it's part of the so it's required, there's no evidence that he intentionally exercised control over that bag. Since they don't know where the bag came from, the officer cannot say he saw it come out of the window. He can speculate all day, but nothing supports that, as there's no fingerprints on the bag. And there are multiple clear bags. He just said there was a clear bag, and there's multiple clear bags in the area. Based on that, we don't believe the state can establish a prima facie case in this case. And the state has stipulated to those facts in their demurrer.
Are you talking about count 1 of trafficking?
Count 1 and 2, tampering and trafficking.
What do you say, Ms. Leon?
Well, Your Honor, generally the facts are as Ms. Dudley has stated. However, the bag with the drugs was found over the fence where there were no other bags or trash. It was clear and is clearly shown on the body camera. A motion to this kind of case that disputes knowledge and possession of the drugs, it's an argument for a jury. The case that Ms. Dudley brought up, McCready v. State, comes from a denial of the court of a judgment of acquittal. It was not based on a motion to dismiss. The issue of knowledge are proper for a jury to decide, for the fact finder. Additionally, in this case, every evidence that is present has to be seen in the light most favorable to the state. The state only has to provide a prima facie case. The officer claimed that as he was chasing the defendant, the defendant was fleeing, he saw a bag flying from the car over the fence. He immediately told other deputies to go look for it. However, the deputies didn't understand the exact location where the bag had been thrown. So Deputy Brooks went himself, and they found it easily, and we're talking about, Your Honor, 140 grams. It's a big chunk of cocaine. So there is no way that it could have just flown or thrown by the wind. There was no wind at the time, and it can be seen on the body camera. Again, the element of constructive possession is a question of fact for a jury to decide, and that's said in State v. Farrugia, 419 Southern 2nd, 118. A motion to dismiss should be granted only where the most favorable construction of the facts would not establish a prima facie case of guilt. If there is any evidence upon which a reasonable jury could find guilt, a motion to dismiss must be denied. The jury can simply decide to believe the defendant or to believe the totality of the circumstances. The defendant was fleeing, and there is testimony during even the deposition that the defendant acknowledged by looking in the rearview mirrors that the law enforcement was behind. And it's our theory that he kept fleeing to have an opportunity to get rid of the 140 grams of cocaine. I would ask the court, based on the case law, to deny the motion to dismiss.
Your Honor, if I may. The state's arguing facts that they didn't stipulate to, or the facts are not in the motion. I can do the same, but for them to say the officer immediately told people, that's incorrect. The officer literally stops, does a canine walk, detains the defendant, and then he says, oh, I think there's something over there, that there's a bag in the air over there. Well, if we go what the state says, 140 grams, she just said the bag wouldn't be in the air, so that's not what the officer saw. The officer says, and the state is stipulated to, that he did not know if anything came out the window. So what facts can be in the state's favor for there is no witness that says the bag came out of the window? That the defendant threw the bag. There is no witness to say so. There is no evidence to say so. So in light of what's favorable to the state, the evidence is the officer said he did not know where the bag came from. He didn't know if it was dust up while they're driving through the parking lot or if it came out the window. He didn't know where it came from. But he can't say it came out the window. That's what matters. And the case law she's citing does not say constructive possession is an issue for a jury. What it says, the knowledge element is an issue for the jury if that's the only issue. That's what it says. And I'm not arguing knowledge. I'm arguing possession, and a part of possession that says intentionally exercise control. And they have no evidence at this point that the defendant intentionally exercised control, even in the light most favorable to the state. Because the only evidence they have is an officer saying he's alleging fleeing, where the car goes not even 1/10 of a mile. But okay, let's say that. He's alleging fleeing, which I disagree is fleeing, but that's not an issue for this motion. But he says, I do not know where that bag came from. An officer went and looked, that is in the facts that the state stipulated to, in the motion, that there were multiple clear baggies on the ground. So what is there to say that that is the bag they're talking about? Because he can't say that the bag came out the window. He never said the bag came out the window. He doesn't know where the bag came from. He tells the officer there's a bag over there. It was a clear bag. I don't know if it was knocked out by the wind. The officer goes. He found multiple baggies. That is in the deposition. That is in the facts the state stipulated to. Like most favorable to the state, there is no witness and no evidence to say the defendant threw the drugs out of a window of a vehicle. The officer never says it. And there are no fingerprints on the bag. So what evidence is there to establish a prima facie case? The state's saying that constructive possession is an issue for the jury. It's not. You got to have evidence for a prima facie case. Knowledge alone is issue. The cases the state cited dealt with exclusive possession. Where knowledge is, you can get inference of knowledge. You don't get inference of knowledge or dominion and control from constructive possession. You only get that from exclusive possession. And we don't have that. And in the other cases, the state cites deal with traverses. They didn't follow traverse. They followed a demure. And in this case, like most favorable to the state, there is no witness to say the defendant ever had those drugs. Nothing at all. So like most favorable to the state, totality of circumstances, what circumstances? Multiple baggies are found on the ground. No one can say that bag came out of the window. No one can say he had it. All the officer can say is what he said on his body camera at depots and what he told the other officer. I don't know where that bag came from. Even it could have got knocked up by the dirt, or it could have came out the window. I don't know where it came from. There are no fingerprints to either corroborate anything because he never saw the bag come out the window. And he can't testify to that. We have no evidence in this case to say the defendant had the bag.
Your Honor, it's the totality of the circumstances. There is no doubt that the officer saw this thing coming from the car over the fence. The fence is misstating the fact. Multiple bags were found before the fence. Over the fence, where actually the officer observed the bag going, there was nothing but that one bag. And it's clear from the body camera. Again, it's a totality of the circumstances. And in the light most favorable to the state, even not like the defense said in our motion, he didn't know if the bag was thrown out or if it was just blown by the wind. So it's either one, right? He didn't know. So if we would need to see it in the light most favorable to the state, the scale will weigh towards the state. Per the words of the defense, it's for a jury to determine. And the jury can decide to believe the defense. And then they can file a motion for judgment of acquittal at that time. So I ask that the motion be denied.
Are you saying that no one saw this bag come out of the car, and you're saying the officer did see the bag come out of the car?
Yeah, the defense even wrote that. Yes.
Is it a deposition?
The officer never says he saw the bag come out of the car.
I mean, is that in a deposition?
What he says is this. He didn't know if it flew for the wind or if it was thrown from the car. He never says he saw it come from the car, ever.
But he doesn't have to say that, Your Honor. It's the totality of the circumstances. He had a belief that that bag was thrown from the car over the fence. They go back, and exactly what Deputy Brooks thought he was going to find that bag, he found it. It was there. So that would be my argument, is the totality of the circumstances.
Why didn't he file a traverse?
Because the facts are not disputed, Your Honor. I'm not disputing that the officer said it either flew from the wind or came from the car. How can I dispute that? But then they went back, they checked, and they found that one bag that is clearly just placed there. Didn't have any other debris around, and there were no other bags around.
Your Honor, even if they find a bag, it still doesn't say where the bag came from. The state just said, the officer stated, he didn't know if the bag came out the window or if it was knocked up in the air. He doesn't know. So you still have no evidence where the bag came from, and there are no fingerprints on the bag.
You know, 140 grams of cocaine couldn't just happen to be there.
Well, I like the state likes to say, I understand the weight of the drugs. That's irrelevant at this point. The point is whether or not they have evidence to say the defendant exercised control over these drugs, and they do not. They have no witness to say the drugs came out of the window. The witness says he don't know where the bag came from. And just because they found the bag doesn't mean that is the bag that the officer saw.
He didn't say he didn't know where the bag came from. He clearly said that the bag came from the car. He just didn't know if the defendant had thrown it or the wind. So he asked the other deputies to go check.
Y'all are confusing me on the defense. Ms. Dudley says, the officer says he doesn't know he didn't see the bag come from the car, right?
This is exact words. He saw the bag, he didn't know if it came, he doesn't know if it came from the car or if it was thrown up by the wind or when they drove through the parking lot. He never says it came from the car. He says he didn't know.
Is that right, Ms. Leon?
It's what he said.
I'm going to say that it's wrong because it's my understanding that what he meant was, I've seen something flying from the car, and there was no traffic, Your Honor. It was like a rural street. He sees this thing flying as he's chasing, and he's very close to the car of the defendant. You can see it on the body camera. And he sees this bag flying. The reason why it's important to notice that it's 140 grams, it could not be the wind blowing this thing over the fence.
Your Honor, if I can approach
That's-
real quick with the motion, the state admitted to the facts in this case. And in
I
those
think
facts, it
there's a
states-
lot of speculation on the state's part that the wind could not have, I'm gonna grant the motion to dismiss.
Thank you, Your Honor.
Prepare me an order on that, but that's not to count 3 and 4.
No, it's not to count 3 and 4. I will file another motion on that case or set it for trial, Your Honor. Yeah. That's all. I have Minor Williams, please.
Stay away from those parking lots that have drugs flying around them.
Judge Gontier, I have nothing further. May I be excused?
If I may approach on Mr. Williams.
Is this minor? This is State of Florida versus Minor Williams, 22 CF 1092 and 24 CF 2154.
Yes, sir.
He's pleading straight up to these.
No, it's a plea agreement, Your Honor. He's in a plea of no contest.
It says he pleads as charged.
Yes, sir, in both cases.
That's what I said.
Yes, sir.
He's pleading straight up to him. I mean,
He's
yeah,
pleading as charged, Your Honor.
not to a lesser included.
No, sir.
All right, Mr. Williams, you please raise your right hand and be sworn. You swear the testimony you give for this court is true, so help you God.
Yes, sir.
You want to enter a no contest plea to 2 counts, well, 1 count in each case of driving with license suspended or revoked, both third-degree felonies.
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
I am, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Dudley's done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates you guilty on both counts, or both cases. $515 court costs per case, 24 months probation on each case concurrent. Show proof of driver's license eligibility. No unpaid tickets or financial obligations on driver's license record. All cases and counts to run concurrent and waive cost of supervision.
Yes, sir.
Your Honor, also the state takes no action on the FTA. We just want to make sure that's on the record, so they will let him get out.
That's correct.
All right. Okay.
Thank you, Your Honor. That's all I have.
Actually, Your Honor, that reminds me on Ms. Billingsley from earlier. She's being held on an FTA. I wanted to make sure that was also no action on that FTA from Ms. Billingsley from earlier this afternoon.
Was she here?
That was, yeah, she pled to a DUI judge.
All right,
Fleeing an
Oh,
DUI.
well, I'll withdraw any capias. I don't know if they're going to stop the FTA or not.
Thank you, Judge.
Aaron Jefferson.
Judge, Mr. Jefferson is present. I've got Dr. Harper present as well. I believe the state emailed me Monday, and they were indicating that their victim had some conflict and could not be here today. And I emailed back and said I couldn't agree to continue it. However, I could agree to, as long as Dr. Harper gets to testify, so she's already had to change her schedule to be here today. So I want to make sure we get that much out of the way, but that's up to the court whether you grant the state a continuance for the balance. But I don't care either way.
Well, was there a written report submitted?
Judge, I don't know if I e-filed it, but I do have a written
Why don't we
report.
just stipulate that so doctor can just go on ahead and go?
Because there has to be live testimony under case law, a report in and of itself, or me saying it doesn't count? For you to find a mitigator and it to stand on appeal?
Well, what does the state say?
I don't mind having the testimony of Dr. Harper, Your Honor.
Just do that part of the case
Right.
today?
Yes, sir.
All right,
Judge, I'd call Dr. Harper.
okay. Mr. Jefferson's been back and forth a dozen times here, I think. Can you hear me okay?
Yes, sir.
Dr. Harper, would you please raise your right hand to be sworn? Thank you. Have a seat. All right, go ahead.
If you would, just please state your name for the record.
Dr. Julie Harper.
And Dr. Harper, do you know Aaron Jefferson?
I have previously evaluated him.
And did you do so as a result of my request?
Yes,
Did you prepare a report?
I did.
Okay. And do you have a copy of that report with you?
I do.
May I approach your honor? And you, what I've marked as Exhibit A, which is the report, want to make sure, is that consistent with the one you have?
Yes, and it should be. Yes.
Very good. Dr. Harper, my questions are, as you evaluated Mr. Jefferson, did a psychological evaluation, did you consider what you learned as a result of that evaluation, whether or not you found any mitigation circumstances that pertain to Mr. Jefferson?
Yes, I found that he had a mental health condition for which he's been treated on an outpatient basis. That's a mood disorder. The court may find that mitigating because he was not receiving treatment at the time of this offense. And at times, his mood disorder has risen to the level that it's included psychotic symptoms. I believe that at this time, because he's participating in treatment, it's not at the same level that it was at the time of the offense.
Do you believe that the mental health issue that he suffers from, do you believe it's unrelated to substance abuse?
Yes, I do.
Do you believe he's amenable to any treatment that would be suggested by yourself or ordered by the court?
I do. He has participated on an outpatient basis at Bridgeway Center. He's been tried on several different medications. He has been consistent in taking the medications, even when his insight as to why he needs those medications isn't fully on. He's not completely aware of, how do I want to say it, the reason that that would be the medication that is needed, and that his condition is a depressive disorder versus psychosis, but he's still consistent in taking the medication. So even without full understanding, he's still compliant.
And I believe that this case originated from an event that happened somewhere in March, into either middle of March or end of March of 22. Did you and Mr. Jefferson talk about, did he self-report and go to Bridgeway for help?
So we've met, earlier this year, January of 2024. His Bridgeway Services records indicate that just after the incident, he self-reported for treatment. And when I met with him, he had a second episode of treatment that he initiated. So the record spans about 2 years.
But after this happened, he went for help?
He did.
Did he indicate to you whether or not he had any memory of what happened?
He didn't have memory of the event itself. He's only been able to kind of retain what he knows about the event from offense reports and victim statements.
Your Honor, I would offer into evidence what I've marked as Exhibit A.
Any objection?
No objection.
So those are my questions.
All right, Ms. Leo, you have a question?
Dr. Harper? Hi, good afternoon.
Good afternoon.
In your report, I read that his condition involves anger. right?
Yes, his depression presents as irritability and sometimes anger.
And now you also wrote that when he self-reported at Bridgeway, right?
Yes.
He just decided not to go there anymore because he didn't like the medication, right?
No, he had a planned termination from Bridgeway.
Well, I read differently from your report. I'm going to refer you to the part that I am. 1 second. Let's see. You stated that he didn't feel the medication he was given was good for him, so he decided to stop.
Can you reference where you're
Yeah, I'm
looking?
trying to find it.
Okay, thank you.
I wrote my
Page
notes.
4, third paragraph.
Oh, you found it, George. Thank you, Your Honor. Yeah, it's right there. He was concerned that the antidepressant was going to control his brain. He stopped attending treatment, right?
He
So
did.
it wasn't, the treatment was not terminated. He stopped.
Well, they did have a planned termination also at Bridgeway, and the record reflects that they had a date in which they were going to reach their conclusion of services. So that is what I'm referring to.
And why did you say that he stopped attending treatment and yet wanted to return to see if another medication may be available? So he
Because-
wasn't done with the treatment, or he thought he wasn't done?
Correct. He was not done.
Now, you also reported that he was using alcohol since the age of 3, right?
He had his first use of alcohol when a parent provided a sip of alcohol to
Very
him at
well.
3.
And also, you've assessed him with severe alcohol use disorder.
That is correct.
And you also report that throughout his life, he's been using drugs and alcohol.
He had a period beginning around age 19 when he had a very serious mental decline and admitted that he began using methamphetamines after. So he did have a lengthy period of time where he consumed methamphetamines until he discontinued that. And all that remained of his substance use was when he returned to using alcohol, and that was more close in time to this offense.
And you described his mood disorder as being irritated easily by others at times.
Yes, that's a symptom of his depression.
Is the majority of the population affected by this?
Is the majority of the population
The community.
affected by what? Yeah.
By being irritated easily by others at times.
Not when it's a symptom like this. So the treatment is designed with the antidepressant to reduce that symptom, and you can see that reflected in the records, that when the antidepressant is used, even his boss was commenting back to him that his level of, or his demeanor was different on the antidepressant.
So the fact that he would get easily irritated by others
Yes.
caused him to ram into innocent victims' cars and pretending he's law enforcement officer.
Well, as I stated, he didn't recall his, I guess, actions on the day. So anything that we would speculate would be that persistent symptoms that he's had previous to the evaluation, previous to the offense, in the records dating back farther, would include irritability, symptoms of psychosis, meaning believing things that are not real. And so those are things that are pertinent to the offense. Both of those things have occurred for him way prior to this incident.
Now, you also stated that at the time of the incident, he was under the influence of alcohol.
Yes, that's right.
No other questions, Your Honor?
Doctor, and I can't remember, so you correct me if I'm wrong. Did I send you the depositions that were taken in this case?
No.
Okay, that's fine. Those are my questions, Your Honor.
All right, thank you. You can step down.
Thank you.
Judge, what date are we looking at to come back?
November 7th?
Your Honor, if the docket allows, we have several matters set already for that afternoon.
What about December 5th?
Again, yeah, if it allows the docket, that's fine.
Judge, I can do December 5th. What time are you wanting to do?
2 o'clock?
It's fine for me, Your Honor.
Judge, I don't know the nature of why the victims couldn't be here, but I would, just for the record, state that the case was set for today to be at 2 p.m., which is October 31st, but that hearing was determined on September 3rd, so that was almost 2 months that the victims had to make arrangements. So I would certainly hope that the December 5th date that we just set will be acceptable.
Okay.
Your Honor, one of the reasons why I also asked to continue it is because after court on Monday, we spoke about the docket that we had today because of the sentencing that is coming up. And I asked if he agreed to continue it. He said yes, as long as we can take the testimony.
All right. Okay, well, no one's mad at
And
it.
he's continued it all this time for 2 years.
All right, December 5th.
So the reason you were, Judge, and I don't like to argue, you know me, I've been doing this for too long, but I was told in an email that her victim specifically could not be here. That's why I said I have no problem as long as we can get Dr. Harper's testimony, but now I'm hearing.
They
that
could
maybe it
not
was
be
for
here,
another
Your Honor.
reason.
I have the email from the victim stating that, and I can forward it to you, Mr.
Y'all
Noakes.
don't need to fuss.
I don't
We're
want-
gonna get it done December 5th.
Yes, sir. Thank you, Judge.
You got the record.
Yes, sir. Have a good day.
You wanna do Akeem Dixon?
Your Honor, we had already continued him this morning.
Oh, that's right. Gregory Spears?
Your Honor, it does say continued on there. We did agree to a continuance. I just know what date, Madam Clerk, continue it to.
Is that gonna be an evidentiary?
Yes.
Well, he has a
Since you
new
say
Laura
he
and,
is in charge.
huh? That's what I mean. He was just arrested for a new charge.
Yeah, let's do December 30th
I
then.
agree.
That's fine. Thank you.
Okay. What we got next? Kelly, David Kelly?
Yes, sir. Mr. Kelly's my case, Judge. It's here for sentencing. His mother's present, and she's going to want to be able to address the court.
Your Honor,
Ken?
We have David
TV?